Hare Krishna. Welcome to Tax YouTube channel. This is C. Rohan Pingrai, practicing chartered accountant based in Mumbai, also partner in Motilal and Associates LLP, member firm of Marks Network. Welcome to the video series What Law Says. And today we are going to discuss two important case laws reported under GST law to the High Court. So let's dive into it. Let me allow to share my screen. Yes. So let's start directly. First case, Shekhar Pandey was a state tax officer, Uttarakhand High Court, and date of order is 16th February 2026, very latest. Let's understand facts of the case. The assessee was a registered person under GST law. Due to certain defaults or reasons, the GST registration was cancelled by the department. Post cancellation, the department initiated proceeding for tax demand. A show cause notice was generated. The show cause notice and subsequent communications were uploaded only on the GST common portal. No physical notice was sent. No email communication was ensured. No alternative mode of service was adopted. Very important. The assessee didn't respond to the show cause notice as he claimed he was unaware of it. So department proceeded past ex parte order confirming the demand. So assessee came to know about the order later and filed writ petition before the High Court. So key grievance, no proper service of notice, no opportunity of hearing. So let's understand issue under consideration. Whether uploading notice on GST portal alone constitutes valid service under section 169, especially when registration stands cancelled. Very interesting. So let's understand legal provisions relevant to this case. Section 169 of the CGST Act 2017 provides what multiple modes of services, including portal upload, email, physical delivery, registered post. So principle of natural justice also relevant here. Audi alteram partem, right to be heard, procedural fairness in adjudication. So moving further, let's understand contentions of the system. Assessee contended that after cancellation of registration, assessee doesn't regularly access the GST portal, correct? Portal upload that is not sufficient for effective communication. Serve notice through other prescribed modes, that no attempt by department to serving the notice through other prescribed modes. Denial of opportunity to reply to the show cause notice and opportunity of personal hearing. Therefore, entire proceedings are void ab initio is what contended by the assessee. Let's see what revenue contended here. Section 169 specifically allows service through GST portal. Once notice is uploaded, it is deemed to be served. Assessee has responsibility to check portal regularly, and hence valid service, valid proceeding is what revenue contended. So let's see what High Court observed and held. Section 169 provides various alternative modes of services, not one. So these modes are meant to ensure what effective communication, not mere formality. Very important. These modes are meant to ensure what effective communication and not mere formality. So court emphasized that law requires service, not merely upload. After cancellation of registration, assessee's interaction with portal becomes limited or discontinued. Therefore, sole reliance on portal is unreasonable and what insufficient. So department failed to use email, physical service, other statutory modes. So result into what assessee was deprived of opportunity to respond. So it held that service of notice is invalid, violation of natural justice, and order set aside. So what principles laid down by this case? Service must be effective and meaningful, not mere technical. Only portal upload, it is not a standalone sufficient mode, especially post cancellation. Department must exercise reasonable diligence in ensuring what communication. Natural justice is very important, overrides the procedural shortcuts. Burden lies on department to prove proper service of notice. So what we can conclude from case 1 today is the case established that procedural compliance must ensure actual communication. Authorities must use multiple modes of service where necessary, and failure leads to what? Invalidation of entire proceedings, that is void ab initio. So moving further, case 2, Deepak Agro Industries versus State of Himachal Pradesh. High Court involved Himachal Pradesh and date of order 24th February 2026. Again, very latest order. Let's understand facts of the case. So, department issued here show cause notice under section 73 for alleged tax shortfall. During the pendency of the proceedings, assessee made payment of tax amount. Important aspect is here, payment was clearly stated as what? Under protest. So assessee's intention is to avoid coercive recovery and not to accept the liability. And that is why assessee made the payment by writing under protest. So despite this, department treated that payment as voluntary compliance. Department action invoked section 73 subsection 8, closed the proceedings without adjudication, and assessee challenged here closure of proceedings and denial of opportunity to contest the demand. So let's see what were the issues under consideration. So whether payment made under protest can be treated as voluntary payment under section 73 subsection 8, whether such payment leads to automatic closure of the proceedings. So very interesting. Let's see what are the legal provisions relevant to this case. Section 73, subsection 8 of CGST Act 2017. Proceedings deemed concluded if tax plus interest paid before adjudication. Concept of voluntary payment and principles of natural justice and right to contest demand. So let's see what assessee contended. Payment was conditional under protest, no intention to accept the tax liability, waive right to contest. So payment made to avoid the penalty or coercive recovery in future. Section 73 subsection 8 applies only and only when payment is voluntary and unconditional. Hence, proceedings should continue what is contended by the assessee. So revenue contended here that payment of tax amount indicates acceptance of liability. Very loose contention. Section 73 subsection 8 allows closure upon payment. No distinction between payment under protest versus normal payment. Hence, proceedings validly closed. So whatever contention by the revenue is, if you see, very loose contentions. So what High Court observed and held, court analyzed intent behind the section 73 subsection 8 is what? To encourage the voluntary compliance. Key requirement, payment must be unconditional and voluntary. But in given case, it is under protest. It is not unconditional. Payment under protest is indicates what? Dispute still exists, show lack of acceptance of liability. So department's assumption is payment is equal to admission is incorrect. Okay. So court held that intent of taxpayer is crucial. Closing proceedings without adjudication is illegal, and it held that section 73 subsection 8 is not applicable in given case. Proceedings must continue on the merits. So what principles laid down by this case? Payment under protest is not equal to voluntary payment. Intent governs the interpretation, and authorities cannot treat all payments as admission of the liability. Taxpayer retains the right to contest and right to adjudication. Section 73 subsection 8 applies only when no dispute remains. So what conclusion we can draw from case 2 is the judgment safeguards taxpayers' right to dispute the liability, prevents misuse of section 73 subsection 8 by department, and ensures what? Fair adjudication process. So thank you so much for patient hearing. If you have any questions, observations, suggestions, then do let me know via WhatsApp, email, or you can also comment below the video. So if you are not yet subscribed Tax YouTube channel, then do subscribe for latest updates and video series like this. Hope you are gaining valuable knowledge from all these updates and video series which we are conducting on Tax YouTube channel. Thank you. Thank you so much once again. Bye bye. Take care. See you soon. Hare Krishna.